my lord, if I can submit in this way that suppression of facts, I shall show just now, your lordship, I have claimed, I have not seen any paper that I am included. Rather, in the writ petition, it is there, I will show that Supreme Court on my RTA application has informed I am not a party in the SLPC before the Honorable Supreme Court. How can they say I am covered? In some cases, they say that my case is covered because there was one newspaper advertisement. My lord, you will be astonished to see, your lordship, that I have said that if there is in paragraph 14, running page 11 in the writ petition, your lordship, they are suppressing. Why, your lordship? If that is their case, that the respondents have never supplied any copy of any advertisement published in any newspaper by which the petitioner has been noticed and made a party in WPC number 51 of 2015 and SLPC number such and such. It is actually my common group of 58 writ petitions, and it is parties means petitioners and respondents were 914, and in the process about 10,000 plus teachers have been employed. I am not only saying for me, my lord, all those who have, it is a fundamental right, everybody can submit, my lord. I humbly submit to allow this one line outside the petitioner's interest also. All the petitioners, those who were the parties, either petitioner or respondent, they are also entitled to get this original party right. That cannot be taken away. That is the constitution bench decided by our country, Honorable Supreme Court of India. Nobody can ignore it. That will be a conflict. There is one fear, or it is shown to everybody that as per judgment, you have been terminated. Let them show that I am a party. Let them show that in any manner, Supreme Court has said, Article 20, Article 14, that fair procedure of hearing should be dispensed with. Not a single word. Even in today's short note, I have received, it is not there. They are not changing that part. They are not saying that I am not entitled to get Article 14 right of fair hearing, reasonable hearing. It is not their case. Their case are only technical. They are parties who have said only bureaucrats, my lord. If I can say in this way, bureaucrats will not give the interpretation of the law or judgments. Your lordship will give. And I'm satisfied, grateful, your lordship is hearing in a full bench to decide the law. This is the Supreme Court for us, for the petitioner's lordship. We cannot go, 10,000 people cannot go. But this will do a social justice. This will, I'm sorry, my lord, I'm getting, maybe I am tense. So, my lord, that is my first case is there. Maneka Gandhi, I will show, my lord. And their suppression, they have not, why they have not filed any counter despite 4 or 5 adjournments, despite taking time on some occasion, because they have to disclose this thing. They have not preferred to disclose this thing. So I am not coming to the, according to my learning, my lord, that inch centimeter issues I am not taking. I am raising this fundamental broad question that I cannot be deprived of. My lord, now I am coming to that, my lord. There is, what is that? They can say they have followed some procedure. Then they have to submit, disclose the what procedure they have followed. They have not followed. I applied under RTA Act. They have not. They have not disclosed anything, my lord. Can you see, my lord, in note, my lord? It is subsequent, with your kind permission, kindly, your worship, kindly see the last document in volume 2 of 3 documents, my lord. It is even on 25/8/2023, I applied in the volume 2, it is page 284, last one. Please. No, it is the bigger one. A spiral binding, volume 2, it is written, volume 2 of 3, within bracket documents. Yes, your lordship.
Page 284.
284, lordship. To the Director of Secondary Education, Government of Tripura, Agartala. Request to supply information and documents for submission before the Honorable High Court of Tripura. Petitioner, graduate teacher, Ishanpur Higher Secondary School, terminated. So I submitted this application. Sir, with due respect, I would request you to kindly supply me the following information and documents for submission of the same before the Honorable High Court. 1. Please inform whether there is any government rule or guideline which have been followed by you for consideration of the common judgment of the Honorable High Court of Tripura in case number WPC 51 of 2014, Koktwma Nath versus State of Tripura and others, 58 petitions disposed of on 7/5/2014, affirmed by the Honorable Supreme Court of India in SLPC 18,993 to 19,049 of 2014, disposed of on 29/3/2017, before issuing my termination letter number such and such dated 23/12/2017, issued by the Director of Secondary Education Tripura, and subsequent termination orders. Please answer yes or no. No reply has been provided, Your Worship. Number 2, if the answer to the above question 1 is yes, please supply to me authenticated true copies of the rules or guidelines. No reply, Your Lordship, nothing has been supplied. Number 3, please supply to me authenticated true copies of all file notes in connection with my termination orders from the stage of receiving judgment of the Honorable High Court of Tripura in case number such and such, Koktwma Nath versus State of Tripura and others, 58 petition disposed of such and such, and affirmed by Honorable Supreme Court of India in SLPC number such and such, disposed of on 29/3/2017, before issuing my termination letter number such and such dated 23/12/2017, issued by the Director of Secondary Education Tripura, and subsequent termination orders. And urgently, so that I can submit the document before the Honorable High Court of Tripura for consideration in a writ petition challenging my termination order. Please supply me the documents and information as my life and livelihood issue is involved in this matter. They do not think, my lord, it should be supplied. They do not think that rule is to be followed. They do not think that Honorable Supreme Court Constitution bench decisions are to be honored. It is an arrogance, my lord, in the administration. It is an arrogance, man. Nothing
Yes.
Your Lordship, I'm in between my submissions on my issues. I'm referring the judgment. Your Lordship, you must may kindly pardon me. In Maneka Gandhi, reported in air 1978 as still 597. May I read, my lord? There are 57 and 58, my lord. I'm reading 58. We may commence the discussion of this question with a few general observations to emphasize the increasing importance of natural justice in the field of administrative law. Natural justice is a great in para 58 of air, you know. My lord, should I read the entire paragraph 58, your lordship? Because this is the beginning of a landmark era of natural justice, order and pardon by the judgment delivered in Maneka Gandhi versus Union of India, your lordship.
With all due respect and humility, the ratio of Maneka Gandhi's judgment, well known to you and well known to us also, was arising from a passport.
My lord.
Post-decisional hearing in passport matter could not have said. The apex court then said Article 14, 19, 21, all of them are linked together and gave that. the case before us
Madam.
is one in which an entire selection process has been set aside concerning teachers, because the revised employment policy itself, under which the selection process was done, was found to be in teeth of several constitutional provisions, 16, and also suffered from lack of guidelines, discretion, untrammeled. And it is not that individual cases were commented upon. Individual cases were cited as examples as to how application of the different yardsticks of the revised employment policy has resulted and could have resulted more in illegality, arbitrary. So the court did not comment upon individual matters in that way. The whole process was in jeopardy or was vulnerable because the revised employment policy of 2003 was held to be ultra-violent. Now, that issue actually has spanned about last. The first challenge was in 2011. So now we are in 2023 September. 12 years it has spanned. You got an order of termination in 2017 December. Your services were terminated in December 2017 by an exchange file. There was no indication in that order that your services have been extended. For 6 months on ad hoc period. So, for all practical purposes and legally speaking, your employment had come to an end in 2017. You were conscious of that. Now, when the extension period of ad hoc service has come to an end, and that extended period is only because of the interim orders passed by the apex court from time to time. All those who were beneficiaries of that selection process under the revised employment policy, under that 2009 advertisement, all have gone out of service, except that there are certain riders that they may face fresh selection process, there will be age relaxation, etc., etc. Now, at this stage, for you to contend that individual repetition of individual employees had to be given a notice and an opportunity of hearing, this is too late in the day to ask for. It was a litigation journey in which the whole lot of teachers were involved, whole lot of state agencies were involved. Very decisive judgment was given in 2014, and 2014 or 17, 2014. Now you are asking for principles of natural justice. When a judgment operates in rem to all those who are beneficiaries of that issue, can individual person say that I should have also been made a party and I should have been given a right of hearing? And if that be so also, this issue was again addressed in that Vijay Krishna case, judgment of 3rd October 2009. That whether those persons were meditating and they were sitting, they were fully aware that their employment has come to an end. Is it not too late in the day? It is difficult for not only the employer, but also our court to say something beyond what the apex court has said in its final order. It has upheld the judgment, except that particular paragraph has been clarified.
May I answer? Because it is a very pertinent question, I must satisfy your lordship. My lord, all these judgments will come later on. Firstly, kindly see on the question of delay in paragraph 20 of the writ petition. I have explained this thing.
This annexure one.
No, I am reading, my lord, paragraph 20 of the writ petition, running page 12, 1, 2.
Yes, just one more. This annexure one, which is an appointment letter of 25th March 2010. This employment or appointment letter arises out of the same selection exercise.
My lord, all are not, my lord, because I am also not directly under employment policy, my lord, which is in any way it can be said it is an affirmative policy of the cabinet government, in legislative government. They were to executive government.
I put a very simple question that this appointment letter arises out of the selection process under the same advertisement.
Same advertisement, your lordship.
You have not stated in your paragraph.
My lord, I have stated that due to advertisement, after advertisement, I have been.
That advertisement date should have been mentioned. That some 2009.
Maybe there is many lacunas may be there, my lord. But I have taken up the broad issue, my lord. I want to read paragraph 20 of the writ petition in the running page 12. Delay I have explained this way, lordship, because I know that may come. That although there is no limitation, in filing a writ petition, as a matter of explanation, the petitioner submits that the first termination order was issued on 23/12/2017. He submitted his representation on 30/12/2017. I submitted representation, no response. Lastly, 2 termination orders have been issued on 31/3/2020. That it is a case of 2020. He was on ad hoc service and getting salary to earn livelihood for his 5 family members. Lastly, the petitioner, in response to his RTA application, learned from the communication dated 22/9/2021. Only last I have learned from that time that I am not a party. They are claiming this thing, my lord. From the communication dated 22/9/2021, issued by the Assistant Registrar Supreme Court of India, New Delhi, there the petitioner was not a party in the SLPC number such and such, State of Tripura versus Sri Koktwma, which were dismissed on 29/3/2017. Thereafter, the petitioner has gone to school. I have gone to school to resume his duties. And what? But he has been prevented from joining his duties and to work. Lastly, he has received a copy of communication dated number such and such, dated 8/9/2022, my lord. And I have filed the petition in 2020. It is not delayed.
You were not on the point of delay. You were not on the point of delay. We were on the point that termination of the employment of all the beneficiaries of that selection exercise came.
I respectfully ask, interrupt your lordship. Suppose, my lord, I am in a temple of justice. In this temple, I have been punished. So, and suppose I am Ram. The executors have punished me, but punishment is against Duryodhana. Duryodhana has not been executed. I am executed. It is permissible. It is not permissible. I am giving one example, your lordship. That is why notice is a must. Suppose I am Ram. Punishment order is against Duryodhana. They must punish Duryodhana only. They are punishing Ram also. Therefore,
there is an undertaking before the Honorable Supreme Court after that cutoff date of 1st March 2020. That is reflected in the order dated one order is of 1st November 2018, paragraph 4. Having considered the matter by a bench presided over by Honorable the Chief Justice, Justice Lalit and Justice K.M. Joseph. Paragraph 4. Having considered the matter, we are of the view that at this stage we ought to permit the state of Tripura to continue to avail of the services of the terminated teachers until the end of the academic session 2020, meaning the academic session 2019-20. 1920 obviously it ends on 31st March 2020. The above direction has been issued in the peculiar facts of the case and the circumstances which have confronted the state of Tripura, and above all, the need of the functioning of teaching activities in schools in the state of Tripura remains unaffected. This is the observation of the apex court upon the undertaking given by the state of Tripura. There is another order. It is of 19 June 2020. Mr. Maninder Singh, learned senior advocate appearing for the state, submitted that after the end of the academic session 2019-20, the concerned teachers have ceased to be in employment, that some of the teachers had participated in the selection and the state had afforded them age relaxation. He also submitted that the state government is contemplating to accommodate some of the teachers in alternate employment. So this is what has been told or stated on affidavit before the apex court.
My respectful submission, my lord. It is for the parties, those who were respondents or petitioners in the writ petition.
There lies perhaps the misunderstanding on the part of the petitioner that he is not covered by this this litigation or this judgment which has been delivered.
My lord, let me then complete my argument, and your lordship will decide. We have full faith about this wiser brain of this Honorable High Court. So we are bound by that because I have said it is the Supreme Court to us, my lord. Well, this is the case. I am relying upon principle of odi alteram, principle of natural justice. No hearing, no notice. I am taking the MD ECIL case, 1994. That is also a reference case. Two benches had two views. Whether while after the inquiry is completed, that should be supplied or not, or instantly it should be punished on the basis of that. Then, my lord,
But that won't be applicable in your case.
on service, my lord, right? But the decision is not I am taking the ratio. Ratio is that if they have relied upon something, if they have taken opinion from someone, I have not unclosed anything, my lord. It is in the public domain.
Please understand, there is a distinction in the two sets of circumstances. One is a dismissal or a removal on a charge against an individual employee because of some misconduct. And there, the whole process of disciplinary proceeding and service of notice, framing of charge, witness, framing of second show cause notice, etc. is contemplated. But it is not the case of anyone that your petitioner or any one of those 10,000, 11,000, 12,000 teachers, they had misconducted themselves. The appointing authority had done something which was ultra vires the Constitution. So that whole process had to go. It is not that you have been asked to explain as to why your employment should be preserved because you have a difference to say that. Probably the teachers were innocent victims of that.
No, my lord, that has been protected under by paragraph 127, my lord. I shall come later on, my lord, to that part.
Yes, when entire selection is stinking, is conceived in fraud, delivered in deceit, individual innocence no place, and entire selection process should be set aside. This is what had happened in this case. Individual notice issue, your main case is that notice has, I have not received any notice. I was not included in the petition, so this judgment will not be acted upon me. This is your main subject. You know the exception to natural justice, the rule of natural justice.
Yes, Your
What is
Lordship.
the exception to rule of?
Your Lordship, I assert, it is, I am entitled to, I assert, Your Lordship. Most respectfully, I assert, Your Lordship. It is the most fundamental.
State selection is set aside, is bad in law, arbitrary, actuated with malice. There is
My
a
lord.
question of
My lord, my lord,
following of principles of natural
my
justice.
lord, my lord. They have not said in the order, in the termination order, in Annexure 5.
What they say.
My lord, if you say so, I have no answer.
Ask.
I have no answer, my lord, my lord.
This is the answer you are.
Your Lordship, Your Lordship,
The question you have to answer.
Your Lordship,
I have no answer. What the?
Your Lordship.
This is the question
What
you have to answer.
has not been contended by the state executive in the order?
You are.
It cannot be brought in the affidavit or in the argument, Your Lordship.
You are on academic discussion. You are harping on the rules of natural justice.
No, my lord, my livelihood, Your Lordship. I am not on academic, my lord. Kindly let me conclude that Your Lordship will.
The court to be swayed by emotions.
I
And
am not, my lord, emotions on the law.
how the
Law decided by constitutional bench, Your Lordship. Kindly have some. No, my lord, I am not unnecessary, my lord. It is my right to life and right to livelihood. It is the constitution bench which has emboldened me. Not only this, then before I submit other, I can refer two things, Your Lordship. Kindly see, this
you are unlawfully benefited.
my lord, see, even after whether the question is now, I am showing, my lord, and kindly
Mr. Saha,
submit.
it is very difficult to identify the persons unlawfully benefited
My lord,
and the persons
No, my
wrongfully
lord, no, my
deprived of.
it is a one view, Lord.
So in
I
this
respect me, my lord. I respect my.
exception to rule
This is one view, Your Lordship.
natural justice.
I respect one view, Your Lordship. My view is that even if, suppose, my lord, even if there is one judgment by naming me, kindly let me say. Suppose in the judgment it has been indicated that Ram should be terminated. Even then, Ram is entitled to get one notice. Well, I am showing one judgment of this Honorable High Court in Division Bench. Kindly see, my lord, in volume 1, at page, my lord, 399. My lord, it is by in this Honorable High Court, single bench, then affirmed by division bench that, oh my lord, after 22 years, I got the benefit.
Relying upon that judgment, us to appreciate that because that judgment obviously is a judgment of a division bench of this court.
My lord.
Here is a matter which has attained finality up to the apex court.
And my interpretation is that Honorable Apex Court has supported my contention because it has not named me. They have given you do according to law. According to law means following the principle of natural justice, allowing me that opportunity, my lord.
This judgment doesn't say that do it again in accordance with law.
It has not said that they can violate law. Is it required, my lord? Not, my lord. Everything will not be written that you have to do according to law.
Please appreciate, you see, you may be harping a point of argument or a line of reasoning from which you have built up your case. But it's also equally important to appreciate the contrary point of view. That this is a case where it is not that individual employees have been handpicked to terminate their employment. It is a case of mass termination of employees because the whole employment process was vitiated due to revised employment policy being ultra-violent.
My respectful, humble submission is there. Admitting everything as it is, my lord. Everything admitting. In paragraph 127 of the judgment, my lord, I am referring again. Can you see, my lord? In volume 1 of 3, my lord, can you see, my lord? Paragraph 127.
Is it paragraph 127 which is creating?
Yes, my lord. My lord, let me explain that because I can expand that thing because I have done some research work on this matter, my lord. That is why I am assertively submitting.
Or you make your effort. Let us.
Okay, my lord. Kindly help me, my lord.
Let let
to
us-
assist your lordship.
Let us indicate the understanding of
Yes,
paragraph.
your lordship. In
Which has earlier been explained also.
paragraph 127 at page 217, I think. I'm reading it. Where is that? Paragraph 127.
Mr. Saab, please. Hear
127.
us. Para
Yes.
127 is.
Running page 217, paragraph 127.
Yes.
Hello. Since we have set aside revised employment policy, which applies to a large category of post and not merely to teachers, we would like to make it clear that our judgment shall be prospective in nature and shall not affect the appointments already made unless the said appointments are already under challenge before the court on the ground that employment policy is illegal. So my employment has not been challenged, my lord. My lord, I pause and refer another thing. In this case, I am saved. If your lordship interpret this in my favor. Supreme Court has also affirmed this judgment in 2-2. That means including this 127. What is this, man?
What is this? We will explain. Before you labor, because, we have also applied our mind, gone through the same judgment time and again, in fact. More than me, brother. have gone.
Let's submit one more,
Got a
one
chance
more line here.
to deal with it.
My lord, this is the prospective of our ruling.
No, please understand. Here, in the case of Tanmay, the entire employment of undergraduate, graduate, postgraduate teachers under a particular advertisement totaling about 10,000 or whatever, under the revised employment policy was in question. The learned division bench of this court held that the policy itself was bad, therefore all appointments had to go. Then, very wisely, at that stage, the learned court must have felt that since the revised employment policy is bad, declared by us, the recruitment, please listen carefully, the recruitment may not be restricted to only teachers in the last 10 years. There might be several appointments in several other departments of the government, which because of this ultra-virus ruling, if we do not clarify that it would be prospective in nature, then all those employments undertaken since 2003 till 2014 would be vulnerable and they would be set aside. They would be revoked by the employer, or somebody will come and challenge, some unsuccessful candidate will come and challenge here. Therefore, they said that this will be prospective in nature unless there is the said appointments are already under challenge in the court on the ground that the employment policy is illegal. So anyone coming in future will not get the benefit. But if there is already a challenge, then that will be determined as per the ratio of this judgment. So that is how 127 clarifies that prospective overruling is prospective and concerning all other employments, not the same set of employees.
My lord.
So let
My
us
lord.
not add to the confusion. It has a very long litigation
My
journey.
lord, my lord. If there are two views, my lord, if there are two views, possible two views.
No two views are possible now because this has been upheld by the apex court.
Therefore, it is supporting me. Therefore, my lord, because neither Honorable High Court nor the Honorable Apex Court has said that I should be terminated without serving any notice, or that protection of prospective of our ruling is not applicable to me.
This notice part anyway is not here, neither here nor
My
here.
lord, my lord.
But even if you say that 127 has been affirmed by the apex court, the meaning of para 127 would remain the same. The entire interim orders of the apex court for extending the ad hoc services are only concerning the beneficiaries of this employment, teachers. out that in that case, Tanmay Nath's case, there was a notice by paper publication by the order dated 6th February 2014.
Has it been disclosed, Your Worship? No, I have applied.
Has taken note of it.
They have not supplied it to me. I have shown in paragraph 15.
This argument won't.
They have not.
It's a notice to the public at large and those who are going to be affected by this litigation exercise.
Under order 1 ruling.
Order 1 state.
At least the notice is to be brought before Your Lordship.
Those arguments in a full bench don't please.
My Lord, that has not been placed on record, my Lord. And my Lord, under CPC, my Lord, that by paper publication, one government employee cannot be implemented and adversely affected. That is my humble submission.
Order 1 ruling. Have you read this
My
provision?
Lord. My Lord. It is
Now tell us about order 1 ruling.
and what I have,
Reading of order 1.
my Lord,
What it
my
contemplates.
Lord, my Lord. Let us submit, my Lord. Let me submit, my Lord.
It was a notice under order 1 ruling.
My Lord, I am not covered by anything. They have not served in notice. Let them sub one notice of me, my Lord. Again, that is, my Lord. Let me submit, my Lord. Let me submit, my Lord. I am before your Lordship, because I am without my livelihood. And my Lord, what is para 127? My humble understanding is that it is the.
That is why you have relied upon that payment dwellers case. That's right.
My Lord. Now, kindly let me submit one thing.
Forgotten.
My Lord, kindly let me submit one thing, my Lord. That prospective overruling is not that it is from the sky has been added. It is the doctrine of prospective overruling as developed in Goloknath. So that is our constitution bans, your Lordship. How can it be interpreted otherwise, my Lord? Suppose in a policy matter, lakhs of people have been given some benefit, it will be always prospective, my Lord.
Difficulty, Mr. Saha, is that the findings, the ratio, everything concerning this employment has attained finality because it was carried in appeal and Supreme Court affirmed it. And in fact, gave a deadline, end of academic year 2019. That is how you also continued till then.
My Lord.
If you were wise enough, maybe you could have raised all these arguments before the apex court by filing an interlocutory miscellaneous application. That I have not been made a party, I have not got a paper publication notice, I should be given an opportunity. All that is lost now.
Your Lordship. If the constitutional bench judgments are not taken into account by your Lordship, then as a common man, as a common citizen, where shall I go, Lordship? And what will be the loss of the state administration?
Principle of finality.
Yes, my Lord. Yes, my Lord.
Finality of litigation.
If one can,
If
so
you suffer from constructive res judicata.
my Lord, let me complete in that case. I complete, my Lord. Let me
When you complete.
in this is a para 127 has been relied upon by this Honorable High Court in WPC 119 of 2020. Another more than one case. One reason is WPC 119 of 2020. It has been followed and benefit has been given. And another case also, WPC 797 of 2020. In two cases, this has been relied upon. Therefore, and in some other cases, notice also has been given back. That it is not that I am claiming only alone. This notice was not served upon a particular person, and this has been allowed by Lordship. Therefore, it is not I am submitting alone. Not that earlier this question has not been considered by this honorable. Notice has been not only this, and even the state respondents also have issued notice upon some persons, your lordship. And that has been quashed by your lordship, by this honorable High Court. Then Article 14 comes, your lordship. It cannot be that they will pick and choose against some person, they will serve notice. And my lord, in my volume 2 of 2, I have enclosed list of several hundreds people, those who are serving, those who were RTI application, it was disclosed that under 2003 employment policy, persons in different departments, in the education department, from my lord, on the first page of the index, bottom last one, information supplied by secondary education in volume 2 of 3, your lordship. Then department, law department, then Directorate of Fire and Emergency Department, Food Department, Police Department, Forest Department, Information and Cultural Affairs Department, Youth, Sports and Youth Affairs Department, Animal Resource Department, Industries and Commerce Department, Elementary Department showing appointments made under recruitment policy, information supplied by higher education department, appointments made under recruitment policy 2003. Again, application, or that is my application. So all these are there that hundreds and thousands of people are serving, some of the education department also. My lord, this is a case where there is a gross discrimination, gross disregard to the Constitution bench judgments.
We have taken your point of natural justice. We have thought aloud about how we have taken it. So you can now move on to another. Paragraph 27 also we have,
One thing, my lord.
we have taken note of.
Yes, ma'am. One thing, my lord, just that recently in the volume 3 of 3, I have referred on this. This. Yes, it is here. It is. HL 1989, volume 1, SCC. Seven six four.
But relying upon some decisions on what proposition?
My lord, suppose your lordship decides, okay, I shall receive one notice now. My humble submission is that this order is a void, not voidable, because it is illegally served upon me. So, on the basis of this judgment, that I am reading, my lord, paragraph 12. What is it?
It's a full benefit.
And the paragraph 12. In our opinion, the post-decisional opportunity, I'm reading from Monopatri. In our opinion, the post-decisional opportunity of hearing does not subserve the rules of natural justice. The authority who embarks upon a post-decisional hearing will naturally proceed with a closed mind, and there is hardly any chance of getting a proper consideration of the representation of such a post.
When you are presenting before a constitutional bench, So first, you need to formulate on what points you are making your submission.
On the principle.
And what, because this is a continuous litigation, it is not a fresh case we are deciding. Earlier, this is also we have decided that it's a settled principle on facts. So now when you are representing, you need to formulate on what point you want to make your submission and what are the authorities, the citations you are relying on, which paragraphs. You need to make the slipshot and then take us.
My lord.
So one judgment is sufficient. If you need to point out on the point of natural justice, you need not read a number of judgments unless there is any other point you need to make out from those judgments. So should we take it that on the point of natural justice you have done?
On the point of natural justice, that subsequent development is there. Post-decisional hearing is not enough. Because in that case, the decision should be declared illegal, void, nullity, and thereafter I shall be in service and I shall may be served. That is my case in this Rehan's case. And that is also this
The judgment what you are now relying, 1989 Supreme Court. The altogether the facts and the principle is different. There in that judgment, the service conditions by way of a circular were amended. In view of the alterations made, so an opportunity of given was the issue. And here the settled issue has attained a finality by the Honorable Supreme Court. And the only thing what the government could have done is, instead of writing one paragraph by way of a memo 31st of March 2020, they could have given a bit of another few lines. But that is the issue why all of us are before this litigation. You need to advise Advocate General. You need to advise your officers the manner in which they have to draft.
Yes. And one is, of course, you are not a party, then principles of natural justice not followed. You are not aware of that paper publication notice. And that even if the case has attained finality, it is not against you. It's a judgment in rem, not a personam, not in rem. And that para 127 post this, prospective overruling. So all these points we have taken note of. So you need not labor further on.
I know. Only one thing, that 127 prospective overruling is on the basis of doctrine of prospective overruling adopted by this one.
That we understand.
Okay. Therefore, the affirming by Supreme Court judgment, Koktwma affirmed by Supreme Court means, including this paragraph 127, means I am protected, my lord. That is why I have encouraged.
We have taken that.
My lord. And my lord, I Honorable Justice Rose also has pointed out one thing, that principle of natural justice is not a straight jacket formula. I appreciate, my lord. That is formula, I agree, my lord. But neither in the administrative order, termination order, nor in the judgment it is there that for such and such reasons I am not entitled. Therefore, if the Article 14 and 21 is this fundamental right, procedural right is in Article 311(2). There are specially grounds given under what circumstances notice can be avoided, my lord. That is my last point. Article 311(2) is the procedure. That is the fundamental right.
That won't
They have not
apply.
followed it.
That won't apply in this case. You are not being dismissed by invoking 311 or the exception to 311.
But if I am in service, I have a right under Constitution. And let me read, my lord, with any permission, your lordship.
Mr. Shah, you are missing the point. See, in personam, if at all your services are terminated or they are faced, if your client is facing an adverse order, fine. But at large, the entire procedure of selection has been set aside. So where is the question of again coming back and issuing a notice? In my judgment and even in the review order, where I clarified, I only said they could have given a detailed note of the procedure of Supreme Court and High Court judgment and some facts. Because even when I read, I couldn't follow it. That was the only observation made. But it was not an order in your favor. Your favor in the sense, a teacher's favor. No.
My lord, that is my case. Your lordship has rightly understood that if two interpretations are possible, which favors me, that may kindly be adopted, and it is my fundamental right, your lordship. And my lord, this is not a paper right, this fundamental constitutional right. There is a rule of law, my lord. That is my humble submission. If this is the rule of law, constitutional rule of law, that may kindly be upheld, your lordship. I am before your lordship. This is my humble submission on behalf of petitioner. This petition may kindly be allowed, your lordship.
Yes, learned advocate.
May it please your lordships. My lord, at the first instance, my lord, I will thank Mr. Saha. It's for him, my lord, that we are before your lordships today. My lord, having said so, I must say one thing. It's an adversarial proceeding, and my submission will be adversarial. My lord, this will be probably the 12th or 13th petition proceeding after Tanmoyanath was decisively decided, after Vijay Krishna came in. My Lord Justice Lord, in one occasion, I was there in the court, had warned openly, my lord, of course, at the insistence of both the party lawyers, desisted from writing it, that instead of spoiling our time in the corridors of the court, gentlemen, advertisements are coming out. Why don't you study and apply for that? You have already got some leverage from Supreme Court, which is recorded in 2 judgments. One, the solace judgment of my Lord Justice Lalit. first objection to the present proceeding and the writ petition is a cavalier petition, as my lord, this word is not my word, it's Supreme Court's words. It's a cavalier petition. Why I say so? My lord, your lordships have seen, we have read and read Koktwma. My lord, from paragraph 4 to 8, the entire gamut of people, the selection process and the appointments which were under the consideration of their lordships were enumerated very, very categorically. My lord, the advertisement date from this to that, selection processes from this to that, posts this to that, appointments this to that. And ultimately at para 121 probably, my lord, the lordship says, therefore, once we hold that the entire process of selection governed by that revised employment policy was read in law, all these appointments and the selection shall and must go, which we hereby do. And then your lordship also says that all these posts now have to be filled up by fresh selection process. And till you fill it up, I'm giving you a leverage till 2014 some date, my lord. I'll just point out. Of saying, my lord, 2017. My lord, I must remind myself, it is at the state's insistence that Honorable Apex Court were pleased to extend the time. Well, it was not their petition. It was our petition telling that we are unable to fill up all the posts within 2014 as granted by the Honorable High Court. So please give us some more time, some more time, some more time. Then the lordships come out categorically. The line is also very beautiful, my lord. Your services will be extended till this academic year, meaning thereby 1920, so that the government doesn't, my lord, misutilizing the word 2020, the government doesn't make it 2020 and 21. The losses were more categorical. Reiterated what we mean by 2020, 2019, 2020 session, and that's all. No, my lord. If someone genuinely wants to ventilate a grievance before your lordship, the lordship, I am not within paragraph 4 to 8 of the judgment. My onerous duty before your lordship would be to say I was an applicant in terms of this advertisement, which is not within 2002-2010. Number two, my selection process is outside the ambit of what has been laid in paragraph 5, 6, 7, and 8. And my appointment is dated so and so. It is not one of those appointments which your lordships were insisting of. He has not done this. Kindly see, my lord, what he has done in his writ petition, paragraph 2. Does it even give a date? Paragraph 2, page 3. I'll read it for your lordships, my lord. Lordships may not take the trouble. Paragraph 2, page 3 of the writ petition in 893.
That is what I pointed out.
Yes, I'm obliged, my lord. They don't come up with any data so as to distinguish, differentiate their case from Koktwma. The single song being reiterated is, I am not a noticee, I am not a noticee, I am not a person. My lord, Vijay Krishna, in no uncertain terms, have decided this. So, my lord, there is a lordships may be sure, my lord, I will not refer to all this. Just for a ready reference, Vijay Krishna is there. Is the first. My lord, may straightway come to page 17 of this compilation, which is also the running page 17 of the judgment. Page 17, bottom of paragraph 3. Lordship got it, my lord. Kindly come to A, B, and C, last line. His clients were never informed of the pendency of any proceeding or implemented as parties therein, and as such, his clients would not be bound by the decision dated so and so referred by this court in Tanmoynath Supra. My lord, kindly come to page 28 straightway for the answer of their lordships. Page 29, my lord. Page 29, findings start at page 28, page 29, bottom, paragraph 18. Lordships got it, paragraph 18, bottom. As such, at this stage, instant writ petitioners cannot be allowed to reopen the entire issue purely on the ground of their non-implementation as parties or non-issuance of notice to them. Who are the petitioners? Are they illiterate rustic villagers hailing from most deprived strata of the society, having no access to justice, also not knowing its procedures? Most certainly not. They are educated government employees posted at several places of the state. Can it be said that they were not aware of the proceedings laying challenge to the appointments made in regard to more than 10,000 posts of different categories of teachers appointed by the government pursuant to the advertisement issued in 2002, 6, and 9? The answer obviously lies in the negative, and the reason is twofold. The pendency of the original writ petitions were widely circulated, and we are informed throughout the state, both in the print and electronic media. So also was the outcome made known. It sent ripples throughout the state. Not only that, prior to rendering of the judgment of Tanmoynath, this court has directed issuance of notice to be published in newspaper, which was also done. There is no factual, my lord, rebuttal to all this. To contend that such directions of notice were confined only to in respect of certain categories of teachers, and as such cannot be construed to be notice qua their categories, is not acceptable. My lord, this is also not their case. That I don't fall within the category of teachers whose appointments were under challenge or, my lord, set aside. It is true that in a service matter, principles laid down under Order 1, Rule 8 CPC may not apply, but then this court was dealing with a case where it stood to observe that the action of the government as a cruel joke on the people of Tripura. The entire selection process was held to be absolutely arbitrary, capricious, and whimsical. It smacks, my lord, these words fell from your lordships at the very beginning. It smacked of nothing less than nepotism and favoritism. Prudently, the writ court thought it fit to issue a general notice and not impede all the 10,323 selected teachers as party respondent, some of whom in any case were before this court. My lord, almost thousands of them were before the court. In a representative capacity, the petitions were considered, argued, and decided. Significantly, none of the instant petitioners laid any challenge to the judgment made in Tanmoynath. Neither did they seek review, nor did they file any appeal. Why so? Remains a shrouded secret. With the dismissal of the SLP and their appointment conclusively found to be illegal, they ought to have been returned home, but for extensions granted by the Apex Court by order dated so and so. Even at this point, they did not express their concern or raise any protest. They are all beneficiaries of this, my lord, process. When the benefit came, they were not telling that I am not an officer. Why do you terminate my service? Or why do you even extend my services? My services are there. Why do you extend them? Obviously, they were waiting in the wings, and only when they fell out of favor of the Lady Fortune, inasmuch as time extended by the Apex Court is expiring, and otherwise not having qualified, they took steps speculative in nature of having the entire issue reopened by challenging the judgment in Tanmoynath Supra. We find their act and conduct to be absolutely despicable. My lord, I stop here. Even after this judgment, yes. Paragraph 20 is also relevant. I'm not reading, my lord, your losses of that. Even after this strong judgment of a division bench of this honorable court, if someone comes with a writ, that too bereft of any factual foundation, so as to bring a case before the, my lord, adjudication periphery of this court, that I am different, and these are points number 1, 2, 3, why I am different. They never say Vijay doesn't apply to me. They never told Tanmoynath, my lord, Tanmoynath is not a judgment in rem. I am not within Tanmoynath. They never say so. My lord, what do I call such petitions? Is it not a cavalier petition? If it's a cavalier petition, my lord, the question will be, what penal consequences will follow? Because we had enough of it, my lord. Since 2019, we had enough of this. Petitions after petitions. Every time your lordships are reiterating that here and no more. Now this here and no more must be in terms which can be expressed most sternly by your lordship, my lord. Not only despicable. It must come out with a penal consequence. Lordship, in a reference of this nature, it's the bounden duty of the petitioners at whose petition the reference is called for to give your lordships the points to be decided. My lord, we have got volumes, not a line on the subject of reference, as has already fallen from my lord Justice Goel, my lord. There is not a single line as to which point this reference is to be answered. Number 3, my lord, I will not speak it aloud, but it's my duty as a law officer of this state, my lord, to point out Rule 4 of our High Court rules. That's all. I'm deeply obliged.
May I add only one line, Your Worship? Because the argument on the part of the Honorable Good Journal is that I have not made out my point. Because I have relied upon principle of natural justice, I humbly submit that in the notice to be given to me, on what grounds they think that I am covered by their judgment, they should mention. The burden should not come upon me, burden is upon them only to be mentioned in the notice, and I shall say it is correct or not. They have not taken anything beyond the mentioning that it is covered by their judgment only. Details should be mentioned by them. If you have like.
So, sir, now we are in a full bench. The orders passed by any learned single judge of this court and even the division benches. Now, by way of this constitution bench, those questions will be answered.
Full bench has been constituted. In view of the reference made by one of us, J, the order dated 30th May 2000 WPC number 893 of 2022. The Since counsel for the petitioner herein relied upon a judgment passed in WPC number 334 of 2021. So and so, so and so. The Honorable Court, after respectfully disagreeing with the decision rendered in WPC number 334 of 2021 by one of us, in bracket T. Amarnath Rod J, bracket close, referred the matter before the Chief Justice of this court, Honorable Chief Justice of this court, to constitute an appropriate bench to decide the reference. Stop. The Chief Justice, in exercise of the residuary powers under the proposed so and so, and all the powers vested in him. Therefore, constituted a successful bench to hear the matter, also take into consideration that at present this court is functioning with a strength of 3 judges only, 5 stands in strength. Stop. Stop me. And that institution of a legal bench at the first instance may not have resolved the issue decisively. Stop. Balance. The appointees to the post of teacher under the advertisements of the advertisements of 2002, 2006, and 2009 appear to revive the issue relating to the termination of their employment, even after the finality reached to the issue by virtue of the judgment rendered by a learned division bench of this court in the case of Tanmay Nath, Nadar Sutra, and other analogous cases dated 51 of 2014, dated, and the matter having been finally affirmed by the apex court in its judgment dated 29 March 2017 in SLP civil so and so and other matters. So, briefly stated, the entire selection process under the selection process to the post of teachers within bracket undergraduate, graduate, and postgraduate under the advertisements of 2002, 2006, and 2009. Where in question before this court in the case of Tanmay Nath and others on inter alia a number of grounds, the main ground being the legality and virus of the revised employment policy 2003, under which the selection process had been undertaken. Stop. A perusal of paragraph 4 to 10, 8 of the judgment in the case of Tanmay Nath would show that all those teachers, that is undergraduate, graduate, and postgraduate, involving how much? 10,123.
10,323.
Involving 10,323 teachers were under question before this court in the case of Tanmay Nath. Stop. The learned division bench of this court comprehensively dealing with the matter and the rival contention of the parties inter alia set aside the entire selection process by declaring the revised employment policy of 2003 as unconstitutional. So, a set of directions were issued which are contained in paragraph 123 to 129.
Setting aside is 122. Setting aside is 122, future course 123 onwards.
121, 122, or so the directions from 123 onwards till 129. The state and certain aggrieved petitioners went in appeal before the apex court. Stop. The operative direction relating to the at para 123 were overstayed by the apex court. Stop. By the judgment dated 29 March 2023, 2017, the apex court dismissed the special leave petitions. However, with certain modifications in para 123 of the impugned judgment. Order dated, judgment dated 29th March 2017 is extracted, quoted here in below. Stop. By virtue of the judgment dated 29th March 2017, the services of all those teachers, including the present petitioner, who was one of the selectees under the same recruitment exercise as a graduate teacher, were terminated by order dated 31st December 2017. Stop. The order in the case of the present petitioner is annexure 5 at page 23 and reads as under. Stop. The apex court, by virtue of the interim orders passed by the apex court at the request, on the request of the state of Tripura, the teachers whose services were terminated were granted extension for ad hoc extension appointed as graduate teachers on ad hoc basis from 1st January 2018 for a period of 6 months, which continued up to 31st March 2020 by virtue of the order dated first November 2018, passed by the apex court in content petition civil numbers 1706 of 2017, in SLP civil numbers 18193-19049 of 2014, and with miscellaneous applications and other connected matters. The order dated 1st November 2018 is also extracted here and there for better appreciation. By virtue of the interim orders passed by the apex court, these persons, including the petitioner, continued on ad hoc basis till 31st March 2020 by the impugned order dated 31st March 2020, annexure 11A. The petitioner was informed that his ad hoc services were terminated with effect from 31st March 2020. Petitioner has thereafter approached this court in the present writ petition referred on 10th October 2022, assailing the termination letter dated 23rd December 2017, and also annexure 5 and the termination letter dated 31st March 2020, annexure 11, issued by so and so. Stop. In order to complete the narrative, it would also be proper to refer to another batch of litigation on the same issue initiated by some of the teachers, that is WPC number 1, Vijay Krishna Saha and others versus State of Tripura and others, WPC number 1040 of 2019, and other connected writ petitions. In the said batch of writ petitions, the petitioners though were beneficiaries of the same appointment process on as undergraduate / graduate / postgraduate teachers claim to be not bound by the decision rendered in the case of Tanmay Nath as affirmed by the apex court. Inter alia contending that A, those petitioners were appointed in March 2010, before which date they had acquired the eligibility in terms of notification issued by the state of Tripura under the NCTE Act 1993, B, the semicolon B, in terms of the selection process undertaken by the state. The petitioners were appointed as graduate teachers. C, the petitioners were never ever informed of the pendency of any proceedings or included as parties and are therefore not bound. Decision dated 7th May 2014 rendered in the case of Tanmay Nath. D, that presentation stood summarily rejected. This court, a division bench of this court, of which one of us within bracket, Arindam Lord J, was a party, was a member, dismissed the writ petitions dealing with holding that the present those bunch of writ petitions were an abuse of the process of law and speculative in nature. Stop. The aforesaid contentions raised by the petitioners in the case of Vijay Krishna Saha and others were also squarely dealt with in the body of the judgment. Stop. The ground of non-impediment as parties or non-issuance of notice, them were also discussed at paragraphs 18, 19, and 20. Stop. Those petitioners had also raised the issue relating to protection under relying upon para 127 of the judgment of Tanmay Nath. Stop. That contention was also dealt with at paragraph 23 to 27 of the judgment dated 3rd October 2019. Stop. Para. It also needs to be mentioned here that by order dated 6th February 2014, in the case of Tanmay Nath, notices were issued to all through paper publication in the light of the principles contained in Order 1, Rule 8 of the Civil Procedure Code. Stop. The decision in the case of Tanmay Nath was thus rendered in respect of the entire selection process under the advertisements of 2002, 2006, and 2009, and conducted in terms of the new revised employment policy of 2003. So, the Ghana division bench in the case of Tanmay Nath found several illegalities and lack of proper guidelines, leading to latent cases of arbitrariness in the selection process and was compelled to set aside the entire selection process undertaken under those advertisements relating to graduate, undergraduate, graduate, and postgraduate staff. When the matter was brought to this court, when the relating to when the termination of the ad hoc services of one of the teachers, that is some of the teachers, that is Pradeep Devramma and two others, in WPC number 34 of 2021, was brought before this court. One of us within bracket P. Amarnath Gaur-J, while after dealing with the rival contention of the parties, found that the memorandum dated 31st March 2020 was not a speaking order and rather an omnibus communication to set aside with the liberty to the respondents to pass a specific order in the subject matter relating to the petitioners. But petitioners, if agreed by the said decision, were granted liberty to avail remedies under law. The state referred a review petition against the said judgment, which was heard and decided by Brother Justice Gaur inter alia, holding inter alia, holding as under paragraph 6 to 8 to 9, 8 to 10, sorry, 6 to 10. So evidently, it was made clear that the court had not granted any relief in favor of the writ petitioner for providing them any appointment or to continue with their services as teachers. So, the decision of one of us, that is P. Amarnath Gaur-J, was brought the notice of the other writ court decided over by one of us, which is J, in the case of the present petitioner, that is the present writ petition. Whereafter, the learned court referred the matter to Honorable the Chief Justice to constitute an appropriate bench to decide the rest. That is how this is stopped. Learned counsel for the petitioner para has assailed the impugned termination letters dated so and so, annexed 5, annexed 11A, on the following grounds. A, that the petitioner was not a party in the writ petitions decided by this court in the case of Koktwma and other connected petitions dated so and so. That no notice before termination was served upon the petitioner, asking him to submit his defense reply. Before the order was passed. As such, there is a violation of principles of natural justice. The counsel for the petitioner has sought to rely upon the decision of the apex court in the case of Gandhi versus so and so in support of his submission as regards requirement of compliance of principles of natural justice as it entails adverse civil consequences. Small 3. Petitioner has also, then counsel for the petitioner has also placed reliance upon the decision, upon paragraph 127 of the judgment in the case of Koktwma in order to submit that since petitioner was not a party in those writ petitions, by the principle of prospective overruling, the case of the services of the petitioner were saved. And counsel for the petitioner has therefore submitted that the services of the petitioner have been terminated in violation of principles of natural justice, though it entails adverse civil consequences, and he was not a party or covered by the decision of this court in Koktwma or before the apex court, where the judgment was affirmed. So, the writ petition is not barred by delay, as not only there is no period of limitation prescribed in writ jurisdiction for invoking writ jurisdiction, and further his services were continued till 31st March 2020. Then counsel for the petitioner has also referred to certain presentations and applications made for furnishing information under RTI before the authorities of the state which have not been heeded. So he has also referred to certain certain answers obtained under RTI from the Supreme Court registry to the effect that the petitioner was not a party in the petition number so and so arising out of before the apex court arising in the case of Koktwma and others. Substance is the case of the petitioner that the case of the decision of Koktwma does not cover the case of the petitioner, and as such, his services could not have been terminated without proper show cause notice and without consideration of his defense applied. Learned Advocate General has strongly opposed it. He submits that the petitioner has not been able to make out a clear case through the pleadings of the writ petition that he was not covered by the category of selectees or teachers belonging to undergraduate, graduate, and postgraduate of belonging categories of teachers that undergraduate, graduate, and postgraduate as have been dealt with squarely under paragraph 4.8 of the decision in Koktwma. The writ petition is an abuse of the process of law, as petitioner has failed to show as to how his case is distinguishable or segregated from rest of the teachers whose appointments were set aside primarily on the ground, whose selection process was set aside primarily on the ground that The revised employment policy 2003, under which the recruitment exercise was undertaken under advertisements of 2002, 2006, and 2009, were found to be arbitrary, illegal, and suffering from nepotism and favoritism. So it is submitted that the decision of Tanmay has been rendered is a judgment in rem, and no individual teacher can claim to be accepted from the rigors of that decision, which has been confirmed up to the apex court. The petitioner can also not complain that that no notice was served upon him, as by virtue of the order dated so and so, passed in the case of 6th February 2014, passed during the proceedings of Tanmay case. Notices were issued to all such teachers to paper publication, in line of the principles contained under Order 1, Rule 8 of the CPC. Stop. And the Advocate General has also placed the decision of this court, division bench judgment of this court in the case of Vijay Krishna Shah and others, where the same contentions have been raised and squarely dealt with, answered by this court. So it is submitted that petitioner has the decision in Tanmay covers 10,323 teachers. So petitioner is also one of them. As such, the plea of non-compliance of principles of natural justice or opportunity to show cause does not arise in the case of individual petitioners when the entire selection process has been set aside. Counsel, Learned Advocate General has also sought to rely upon certain decisions. Sought to rely upon the decisions which have already been referred to in the previous part of this judgment. So, we have given anxious consideration to the rival submission of the parties. So, it needs to be mentioned at the outset that by virtue of the judgment rendered in review petition number 40 of 2023 by one of us within bracket T. Amarnath J. It has been abundantly made clear that the writ court had not granted any relief in favor of the writ petitioners for providing them any appointment or to continue with their services as teachers. So, the referral order dated 30th May 2023 passed in WPC number 893 of 2022 has elaborately discussed the referred to the judgments rendered by this court in the case of Tanmay Nath and others, dated so and so, Sri Vijay Krishna Saha and others, dated so and also the judgment of the apex court dated 29th March 2017, whereby the case of whereby the decision in Tanmay was affirmed. Certain modifications in paragraph 123 of the order of the judgment in Tanmay case. Stop. However, since at the fag end of the order, it was the judgment passed in WPC number 334 of 2021 was brought to the notice of the learned court. The matter was referred to Honorable the Chief Justice to constitute an appropriate bench to do the case. That's all. After hearing learned counsel for the parties at length and after giving anticipation to the tribal submission of the parties and the points raised, we are of the unanimous view that the issue of legality of the appointments undertaken under advertisement number of 2002, 2006, and 2009 in terms of the revised employment policy of 2003 have attained finality by virtue of the judgment rendered by the apex court in the case of so-and-so dated 29th March 2017, whereby the decision of the division bench of this court in the dated so-and-so in the case of Tanmay has been affirmed. The entire selection process, the relevant paragraphs of the judgment in the case of Tanmay have already been quoted here in above. The order of the apex court dated 29th March 2017 and the interim order passed thereafter by virtue of which ad hoc extensions were granted to the features like the petitioner to continue till 31st March 2020 have also been referred to here in above. The decision in the case of Tanmay is a judgment in rem which operates as regards all the appointees, selectees under the advertisements of 2002, 2006, and 2009 and covers 10,323 teachers of different categories, that is undergraduate, and postgraduate, including the present petitioner. Petitioner, it is not that proper notice was not issued upon all the appointees / selectees under the aforesaid advertisement, as by virtue of the order dated 6th February 2014 in the case of Tanmay, notices were issued to all through paper publication in terms of order 108 of the CPC. It appears that this petitioner, despite valid notice, did not choose to intervene in the batch of writ petitions decided in the case of Tanmay, nor did he approach this court earlier after the termination order dated so and so annexure 5 and continued to enjoy the ad hoc extensions to his service till 31st March 2020 in terms of the order passed by the apex court. The present case of the petitioner is not one where his services have been terminated on charges of misconduct, where the principles enshrined under Article 311 of the Constitution of India can be read in. The entire selection process was set aside as the revised employment policy of 2003 suffered from various illegalities, arbitrariness, lack of guidelines, arbitrariness, favoritism, and nepotism in the process of appointment. The learned division bench of this court had directed fresh policy to the employment policy to be framed and selection process to be undertaken. Fresh selection process to be undertaken after giving some relaxation to the appointees whose services were terminated. It therefore doesn't lie in the mouth of the petitioner to contend that the impugned termination orders dated so and so are suffering from violation of principles of natural justice, and that petitioner is not covered by the judgment of this court in case of Hanmenath as affirmed by the apex court. So, in fact, the contention of the petitioner relying upon para 127 of the decision of Hanmenath also has been squarely dealt with by the division bench of this court in the case of Vijay Krishna Shah, and the reasons are the greatest. As is apparent from a reading of para 127 of the para 127 of Hanmenath's case, it can't be read in isolation from the preceding paragraphs starting from paragraph 121, 122, and the nature of directions passed by the court contained in paragraph 123 to 126 of the judgment. So, it is quite obvious that since several employments could have taken place under the revised employment policy of 2003 concerning other departments which were not before the court in the case of Hanmenath, within bracket, which covered the case of teachers under education department only, the learned court was conscious, the learned court consciously clarified that this decision would operate prospectively unless, as regards other appointments made, unless the judgment would operate as regards the appointments made under the advertisement dated 23rd March 2009, 23rd September 2009, unless any employment made in any other employment made under any other department was already under challenge on grounds of on the ground that the employment policy is illegal. As such, para 127 does not confer any benefit or leverage to the present petitioner to escape from the rigors of the decision rendered by this court in the said case as affirmed by the apex court. So, the litigation journey, as observed at the outset, has gone for almost 12 years by now, since the first writ petition was filed in the year 2011. The beneficiaries of that selection process ought to have obeyed the judgment of this court in the case of Hanmenath, and as affirmed by the apex court by judgment dated 29th March 2017. Instead of raking up the issue, taking up their grievances on non-issues, this court therefore deprecates the approach of the petitioner in indulging in an abuse of the process of court once the decision of this court has attained finality by virtue of the judgment rendered by the apex court, and none of the points raised herein are such novel points which are available to be raised by the petition. As observed here in above, we are of the unanimous view that no interference is called for in the impugned orders, whereby the services of the petitioner have been terminated. Stop. The writ petition is therefore, the reference is answered accordingly. The instant writ petition is dismissed.
Yes.
Dismissed with a cost of 25,000 to be deposited in the state legal services department.
They are unemployed.
They should be conscious, and others also should become conscious.